Amendment, Fourth Amendment, Fifth Amendment, we've done a whole bunch of them earlier. None of those either have ever been used by a court to uphold an existing gun regulation. The First Amendment deals with free speech, as I understand it, and those who support open carry state that openly carrying guns isn't just about self-defense, it's about speech. You are making a statement about your position on guns. And I would just briefly address that by saying you can't yell fire in a theater because we've decided it's too dangerous. And by the same token, if legislators decide carrying guns is not a necessary way to communicate that speech, that there are viable alternative methods, the First Amendment is neither a bar to this legislation. I don't want to miss the question that was addressed, which is how are people to protect themselves? We do have a concealed carry permitting system in this state. I'm not are you going to be rude, or are we here?
No, but come on.
Okay, so we have a concealed carry weapons permitting system in California. I'm not here to address that today. That's not what the subject of discussion is. There may or may not be imperfections or flaws in that system. That's something that should separately be addressed if there are people here who disagree, which the rude laughter certainly suggests. In which case, use the system. Go to your legislators, go and seek to have that legislation addressed. But for today, concealed carry permitting systems do exist for those who want to carry weapons for specific reasons of defense, because they are whatever the categorization is that you apply for a permit, and law enforcement has discretion to evaluate those permits and make a determination as to whether you should be allowed to carry a concealed weapon. Again, I'm not addressing that legislation today. I've certainly heard arguments for and against it. If you believe that it needs to be adjusted, then that's certainly something that you're within your rights to try and advocate for. But today we're talking about open carry and people carrying weapons that are dangerous in public, and that is something that I think is absolutely an essential law.
Without ammunition. Nathan, do you have a rebuttal or piggyback on that?
The whole open carry movement is in kind of an interesting position in the fact that loaded open carry is banned except in the most unincorporated areas where there's no regulation against discharge. And then you have a May-issued concealed weapons permit system, which is based on Florida's Jim Crow laws from 1893. And those were instituted in 1923, and according to several news articles at the time, it was to quell, quote-unquote, Asian and Latino gang fights. So, with the institution of that system, they made it was basically nigh impossible for anyone to carry a firearm unless you were white, wealthy, and a friend of the sheriff. And that system has pretty much continued well into today. It's a very valid question to ask, how do people, the aged, the weak, the women, defend themselves in this time and place? Especially considering that police are not required to respond to calls for help. They don't have to come to your house. They don't have to defend your life. It's been upheld in the Supreme Court. It's actually delineated in the California State Constitution. And I quote California Government Code sections 821, 845, and 846, which state, neither a public entity or a public employee may be sued for failure to provide adequate police protection or service, failure to prevent the commission of crimes, and failure to apprehend criminals. We also have a one DC, which says police are not required to protect you against madmen and rapists and killers. What was the second question?
Too far away. You're the young guy, I'm the old guy.
Yeah, well.
I don't remember the second question, but it had to do with gun issues.
Oh, okay.
I think the question was three common sense reasons for carrying a gun.
Oh, okay.
Common sense reasons, preferably.
Right. Okay, well, for one, police aren't required to protect you, and when seconds count, police are minutes away. Second good reason is because the right to life deserves the right to protect that life. And third, that's a good third reason.
You don't need to.
Constitutional right. That's all I can say.
That's we just determined that wasn't constitutional right.
This isn't a legal forum, but let's talk about the constitutional right a moment and get people to address it a little bit. My understanding is there have been a couple of decisions, the Chicago case, the DC case, and so forth. And one of the quick readings I did was an opinion by Justice Scalia that the Second amendment is inviolate. I mean, it's there, it's part of the Constitution, and it's not going to be abridged. But he said there also, as I understood what his opinion was, there are certain limitations that can be imposed on this Second Amendment in special cases. Now, if I misstated that, I'm sorry. I'm just trying to give it my best paraphrase. I would like to know, are there differences in first of all, address that issue and what you're doing to it with your bill if it passes. And I understand your bill has a lot of support from editorial boards and so forth. And give us your assessment of where it is in the legislature and what the governor may do, if he has endorsed it or not, and so forth. There's also address the issues of rural versus city, if you will. And you know, they can go both ways. I can see where it could be more important to have a gun in a city than in a rural area. I can also see, as a guy who grew up hunting rabbits and pheasants, I can remember that was a thing that we had in rural areas. So, Representative Saldana, why don't you start with that one, and we'll just come right down the table and a little bit free range.
Well, the Supreme Court rulings, there have been two in the past year. A year ago, it had to do with Washington, D.C., and Heller versus Washington, D.C. And specifically, they ruled that a person does have a right to own a gun in their home. Because up to that point, the District of Columbia was not allowed the ownership of firearms at all. So the Supreme Court ruled in the D.C. case that an individual residing in a District of Columbia area could own a firearm. But that was a federal district. They didn't rule on anything beyond the federal district. McDonald, in the case of Chicago, ruled on the broader constraints. And what they found is that, again, in a person's home for personal safety on private property, a person has a right to own a handgun for personal protection to defend their home and property. Now, the Supreme Court is not prescriptive. They don't say, therefore, given these two rulings, local jurisdiction, state government may do the following. That is not the role of the Supreme Court. They interpret what is put before them. There were two cases put before them. They ruled in both cases in the district setting, a federal District of Columbia setting, and then in the city of Chicago. And in both cases, they made it clear that reasonable restraints on guns in certain places is not being overturned by those decisions. That those decisions did not say any gun, anytime, in any place. So reasonable restrictions may be allowed to be put in place. And so that is what this bill is introducing. Reasonable restrictions on the open carry of guns. Unless you are a trained professional law enforcement person, I don't believe that you would be able to respond in a life-threatening situation accurately and safely. I have seen no evidence to that effect. And I would like to know how many people who are open carriers have gone through law enforcement style training to make a determination when deadly force is necessary.
Military training.
Military training,
That's
not civilian
twice a
law
year.
enforcement training.
That's actually kind of a loaded
I just
question.
asked one question. It's a loaded question.
Well, certainly it is. Certainly it is a loaded question
And
because
so if no
what
one has had the training to do professional law enforcement standards of response, I think that reasonable restrictions are reasonable for public safety.
Let's follow with Robin and Nathan, please, at the end. And we'll get your.
I think I've sort of explained, I think, our sort of basic legal take. The Scalia decision in Heller, and Heller was 2008, McDonald was just the end of June last month. In both cases, especially particularly in the first case, Scalia said that reasonable restrictions, long-standing restrictions, and he referred to what he said was a nice list where he talked about restrictions on the commercial sale of firearms. He talked about restrictions on firearms in sensitive places. He talked about restrictions on particularly dangerous weapons like assault weapons. And he listed those as all viable regulations, even in light of this decision, which held for the first time for an individual right. So he was outlining, and he said, this is by no means an exclusive list, meaning that it was certainly viable that there were other restrictions that were fine. He wasn't trying to prescribe the number of regulations that were viable. So that's in Scalia's decision, and for those of you who are or aren't really in tune with the Supreme Court, Scalia is a pretty die-hard